अस्सलाम वालेकुम, मैं हूं तसव्वुर सियाल। आज मैंने जिस जजमेंट का इंतखाब किया है उसमें जो इश्यूज रिसेंटली जुलाई के महीने में सुप्रीम कोर्ट ऑफ पाकिस्तान ने डिसाइड किए वो दैट वाज रिलेटिंग टू इलीगल डिस्पोजेशन एक्ट। सबसे पहला इशू जो इसमें डिसाइड हुआ वो ये था कि वेदर इलीगल डिस्पोजेशन एक्ट 2005 इज अ यूनिक लेजिस्लेशन एम टू सेफगार्ड legitimate owners and occupants of immovable properties। तो इसका सुप्रीम कोर्ट ऑफ पाकिस्तान ने इसको इस तरह डिसाइड किया कि यस, इलीगल डिस्पोजेशन एक्ट 2005 इज अ यूनिक लेजिस्लेशन एम्ड टू सेफगार्डिंग legitimate owners and occupants of immovable properties from being unlawfully or forcefully deprived of their possessions by illegal occupants or grabbers। तो ये सेटल हुआ कि ये यूनिक टाइप ऑफ लेजिस्लेशन है जो लेजिटिमेट ओनर्स को लैंड ग्रैबर्स और लैंड माफिया से बचाती है। सेकंड इशू इसमें यह था कि व्हाट इज द सेटल्ड प्रिंसिपल ऑफ लॉ फॉर कंप्लेनेंट in order to make out a case under section 3 and 4 of the Illegal Dispossession Act 2005। इसको ऐसे डिसाइड किया गया कि it is settled principle of law that in order to make out a case under section 3 and 4 of the Illegal Dispossession Act 2005, complainant has to prima facie establish before the court that he is the lawful owner or was the occupier of the subject property। That was the precondition कि वो कोर्ट में ये सेक्शन 3 and 4 की लाइट में साबित करेगा कि he was the lawful owner or legal occupier of that property। Issue number 3 was that whether the Illegal Dispossession Act 2005 imposes any precondition on the basis of which a particular class of offenders could only be prosecuted। Yes, this issue was decided that no provision of the Illegal Dispossession Act 2005 imposes any precondition on the basis of which a particular class of offenders could only be prosecuted। Issue number 4 was whether a person can be tried under an act which entails civil liability under civil law and criminal penalty under criminal law for both kind of proceedings। That was very interesting। This question was decided in the terms that yes, any act which entails civil liability under civil law as well as criminal penalty under criminal law, such as the Illegal Dispossession Act 2005, then a person can be tried under both kinds of proceedings which are independent of each other। Next question was that what are the conditions for invocation and application of section 7 of the Illegal Dispossession Act 2005। This question was decided that interim order under section 7 of Illegal Dispossession Act 2005 can be passed when prima facie it is established to the satisfaction of the court that the accused is in unlawful possession of the immovable property and complainant is either owner or was in a lawful possession of the immovable property before dispossession। This was the first part of judgment which was purely related with the Illegal Dispossession Act। Next, question number 6 is relating to power of acquittal of the court provided under section 265K and 249A Cr.PC। Supreme Court decided a question that what is the scope and applicability of section 265K and section 249A Cr.PC। The answer is that the CRPC has granted an inherent jurisdiction by virtue of section 249A and 265K to the trial courts to acquit any or all accused at any stage of the judicial proceedings for reasons to be recorded after providing an opportunity of hearing to the parties। So trial court, either sessions court or court of magistrate, may acquit the accused at any stage after hearing the parties। The next question was that whether section 265K of the CRPC is designed to prevent unnecessary trials when a conviction is unlikely। The question was decided that yes, section 265K of the CRPC is designed to prevent unnecessary trials when a conviction is unlikely। Next question was that whether the provisions of section 249A, section 265K and section 561A of the CRPC should normally be pressed into action for decision of a fate of a criminal case? The answer was that no. The provision of Section 249A, Section 265K, and Section 561A Cr.PC should not normally be pressed into action for decision of fate of a criminal case. The last question was that whether departure can be made from the settled principle of law that in normal circumstances full-fledged trial has to be conducted providing fair opportunities to the prosecution to prove evidence. The answer was yes. Yes, departure can be made from the settled practice when extraordinary circumstances are shown. Meaning thereby, जब prosecution का केस में ऐसी कोई शहादत ना हो जिसकी बिना पर कन्विक्शन स्कोर की जा सके या पार्शियल एविडेंस रिकॉर्ड हो जाए और उसमें इतने कंट्राडिक्शंस हों तो अदालत किसी भी स्टेज पे एक्यूज्ड को एक्विट कर सकती है। तो ये थी आज की जजमेंट। इस जजमेंट की साइटेशन और ये सारे क्वेश्चंस आपको वीडियो के एंड पे मिल जाएंगे ताकि आप इसको अगर लॉ साइट पे जाके विजिट करना चाहें और पढ़ना चाहें तो आप पढ़ सकते हैं। ये रीसेंट जजमेंट है जो जुलाई 2024 में सुप्रीम कोर्ट ऑफ पाकिस्तान ने रेंडर की। इंशाल्लाह मिलते हैं नेक्स्ट वीडियो में एक नई जजमेंट और नए क्वेश्चंस ऑफ लॉ के साथ। थैंक यू।